5 seconds to go. Start. From the aforesaid pronouncement of law, it is vivid that an amended rule cannot affect the right of a candidate who has qualified as per the terms stipulated in the advertisement and is entitled to claim a selection in accordance with the rules as they existed on the date of the advertisement, that the selection can be regulated by stipulating a provision in the rule or laying a postulate in the advertisement for obtaining minimum marks are not prescribed for viva voce before the commencement of the selection process. The authority during the selection process or after the selection process cannot add an additional qualification that the candidate should also secure minimum marks in the interview, that the norms or rules as existing on the date when the process of selection begins will control such selection, and that revisiting the merit list by adopting a minimum percentage of marks for interview is impermissible. The factual scenario in the present case has a different backdrop. The advertisement stipulated that the shortlisted candidates would be called for interview before the final selection, and mere fulfilling of minimum qualification by itself would not entitle any applicant for being called for interview. Thereafter, in the instruction, the marks were divided, regard being had to the level of the post and the technical legal aspects which are required to be dealt with. A concise decision was taken to fix 65% marks for OBC category in toto, that is marks obtained in the written examination and marks secured in the interview. It is not a situation where securing of minimum marks was introduced which was not stipulated in the advertisement. A standard was fixed for the purpose of selection. Instant is not a case where no minimum marks prescribed for viva voce, and this is sought to be done after the written test. As noted above, the instructions to the examinees provided that written test will carry 80% marks and 20% marks were assigned for the interview. It was also provided that candidates who secured minimum 50% marks in the general category and minimum 40% marks in the reserved categories in the written test would qualify for the interview. Entire selection was undertaken in accordance with the aforesaid criterion. After conducting the interview, marks were added to written test. However, since benchmark was not stipulated for giving the appointment, what is done in the instant case is that a decision is taken to give appointments only to those persons who have secured 70% marks or above marks in the unreserved category and 65% or above marks in the reserved category. In the absence of any rule on this aspect in the first instance, this does not amount to changing the rules of the game. The High Court has rightly held that it is not a situation where securing of minimum marks was introduced which was not stipulated in the advertisement standard was fixed for the purpose of selection. Therefore, it is not a case of changing the rules of game. On the contrary, in the instant case, a decision is taken to give appointment to only those who fulfilled the benchmark prescribed. Fixation of such a benchmark is permissible in law. This is an altogether different situation not covered by Himani Malhotra case. The decision taken in the instant case amounts to short listing of candidates for the purpose of appointment, which is always permissible. For this course of action of the CCI, justification is found by the High Court noticing the judgment of this court in the state of Haryana versus Subhash Chandra. In that case, Rule 8 of the Punjab Civil Service Judicial Branch Service Rules was the subject matter of interpretation. This rule stipulated consideration of candidates who secured 45% marks in aggregate. Notwithstanding the same, the High Court recommended the names of candidates who had secured 55% marks and the government accepted the same. However, later on it changed its mind and High Court issued order directing appointment to be given to those who had secured 45% and above marks instead of 55% marks. In appeal, the judgment of the High Court was set aside, holding that it is contended that the state government have acted arbitrarily in fixing 55% as the minimum for selection, and this is contrary to the rule referred to above. The argument has no force. Rule 8 is a step in the preparation of a list of eligible candidates with minimum qualifications who may be considered for appointment. The list is prepared in order of merit. The one higher in rank is deemed to be more meritorious than the one who is lower in rank. It could never be said that one who tops the list is equal in merit to the one who is at the bottom of the list, except that they are all mentioned in one list for the purpose of appointment. Stop.